lawyers do. Thank you all for showing up today. We have two great speakers for you, and we also have a great moderator, Professor Cohen. I'm going to go ahead and hand it off to him to introduce our speakers, and we're going to go ahead and get started. Thank you, guys.
Hello, welcome everyone. Thank you for coming to this event. I was drafted into moderating this at the last minute, given some of the circumstances around here today. So I'm glad to see so many people here. And also, it looks like this is being recorded, which Pennsylvania is a two-party recording consent state. So if you have any opposition to your being recorded, if you are going to be asking questions or anything of that sort, you should get up and leave. And that's your consent. But I know that we have to say that before we record things in this state. So, so that's what I'm doing. So anyway, we have a great discussion today, debate, if you want to call it that, discussion, if you want to call it that, about President Obama and some of his immigration actions, executive orders, and some of the cases around that that are bubbling up in the lower courts, with two real experts on the issue to present different views on this. And so I'll introduce our guest and my colleague who are going to be talking about this. I'll first introduce our guest. Josh Blackman is a professor, an assistant professor of law at South Texas College, which is in Dallas, am I right?
Houston.
It's in Houston, I got it wrong.
Close.
So it's in Houston.
Texas is a big state.
Yeah, it's very big. He graduated from George Mason University School of Law and is the founder and president of the Harlan Institute. He's the author of the book Unprecedented, The Constitutional Challenge to Obamacare, and also has authored over a dozen other articles about constitutional law. In addition, Professor Blackman filed an amicus brief on behalf of the Cato Institute in the Fifth Circuit case of Texas versus the United States, which we'll be talking about, regarding the constitutionality of President Obama's Deferred Action for Parents of Americans in Lawful Permanent Residence Program, otherwise called DAPA. Not on his bio here, but I know it because he's a prolific writer online, interesting issues around constitutional law in the Supreme Court, also studies the Supreme Court and their voting patterns, has tried to model the Supreme Court.
What do you mean
guess the outcome of Supreme Court cases, and also has a Supreme Court fantasy website.
Which kicks off today, Fantasy SCOTUS. You can play right now.
So if you're interested in the Supreme Court and predicting outcomes of Supreme Court cases, you can be involved in the fantasy baseball or fantasy football law geek version of it, courtesy of Professor Blackman. And then my colleague, Professor Kalhan, currently teaches here at Drexel. His principal interests include immigration law, criminal law, U.S. and comparative constitutional law, privacy and surveillance, and international human rights law. He's the chair of the New York City Bar Association's International Human Rights Committee. In early 2015, he was a visiting scholar at the Center for the Study of Law and Society at the University of California, Berkeley School of Law. Before he was here at Drexel, he was a visiting professor at Fordham University School of Law and an associate in law at Columbia University School of Law, and he previously worked at Cleary, Gottlieb, Steen, and Hamilton in New York City. He's also previously worked for the ACLU Immigrants' Rights Project in New York, and served as a law clerk on the Second Circuit and the Southern District of New York. So the format we're going to use, each of them are going to talk for about 15 minutes, and I'll try and keep them to that 15 minutes, and then we'll take questions from you or questions they may have for each other. And so I'm just going to shuffle to the side, and I think Professor Blackman is starting.
Yeah. Hi, everyone. I'm glad you showed up. Despite whatever threats may exist, we will not suffer from the fears of terrorism. We shall overcome. So I thank my good friend Anil and David Cohen for attending this today. This is an awkward spot for me. I am arguing for a position I don't agree with. So as a matter of policy, I agree with the president's positions. In fact, I supported the DREAM Act. I supported the bipartisan immigration reform bill that didn't even come up for a vote. So I'm in this weird position where I think something is good policy, but unconstitutional. And for whatever that's worth, I do like to put that out because I don't pretend that I agree. In fact, the brief I filed on behalf of Cato is all scholars who agree with the policy, but not the manner in which it has been implemented. So I'd like to put that at the outset. So what are we talking about today? We're talking about executive action immigration. And let me start with a brief history of immigration on Capitol Hill before I get to immigration from the White House. So one of the first major pieces of immigration reform the president tried to push through is something called the DREAM Act. The DREAM Act would have provided a pathway to citizenship for certain minors who came here without authorization. And as long as they graduate high school or college and meet other various conditions, they would be able to have a pathway of some sort to citizenship. I think that was a good bill. I would have voted for it had I been on Congress. But for various reasons that are beyond the scope of our debate, it was not voted into law. Okay. About 6 months after the DREAM Act failed to become law on Capitol Hill, the president announced a policy that became known as DACA, D-A-C-A, Deferred Action for Childhood Arrivals. And I want to make one thing very, very clear, because this debate's often mistook. This is not amnesty, okay? This is not executive amnesty. This is not granting citizenship to these aliens. It is not doing any of those things, and I hope you do not use those terms, because that really just degrades the entire debate. What DACA did do was it used something called deferred action, okay? What is deferred action? Now, deferred action isn't actually defined per se in the INA, the Immigration and Nationality Act, which is celebrating its 50th anniversary, I think, this month. But it's this basically process by which the executive can tell a person, okay, we are not going to deport you for some period of time that is revocable, and we're not going to deport you. We're going to prioritize someone else above you. Due to the various regulations that have been promulgated the last 30 years, one of the consequences of giving someone the deferred action status is that it triggers what's known as work authorization. That means a person can lawfully work in the United States, and they pay taxes and all this other stuff. So the DACA beneficiaries, who are mostly people, again, who came here as minors when they were, without permission, without legal authorization, they were granted this work authorization. Fine. That affected, what, 1 million people, give or take? I forget the exact number, about a million people. Hi, guys. Welcome. Come on in. No, it's okay. Come on in. Enjoy. Parties are starting. Okay. So that was the first action we're talking about, DACA. The second action emerged after the defeat of what's called the bipartisan bipartisan immigration bill. This would have been a massive piece of legislation that would have provided a pathway to citizenship of sorts for roughly, what, 11 million, Anil? I forget the exact number, roughly 11 million, give or take, people.
There are 11 million undocumented.
Right.
Not necessarily provided that for everybody.
But for a significant number of people, provided them a pathway to citizenship. Again, this bill did not become law. It was defeated. It wasn't even brought up for a vote in the House, which I think was a very shameful move, but that is the political realm in which we reside. Okay, so on the day the House didn't vote on it, the president gave a speech, I think in the Rose Garden, where he basically said, and I don't have the quote in front of me, but he basically said, if Congress won't act, I will. And I'll do everything in my power to, come on in, it's fine, come on in. I will do everything in my power to deal with this immigration problem. Oh man, late arrivals. Okay, so what happened? Over the course of that summer, and there's a great New York Times article that discusses this, the president and DHS and his various departments and OLC went back and forth and tried to find some sort of executive action that can be taken. And there's a story from the New York Times, you can credit for what you will, but apparently the president rejected, I think, several proposals which he said didn't quite go far enough. And at every junction, the president said, you need to go further, you expect more aliens, okay? Finally, in November of 2014, about 2 weeks after the midterm election, the president went on national television and announced a policy that became known as DAPA. And what DAPA stands for, I've stopped trying to figure out, because it's changed at various points. But we'll just call it DAPA. What does DAPA do? Primarily what it does is it seeks to grant deferred action, okay, to the parents of U.S. citizens and LPRs, lawful permanent residents, okay? So while, again, to clarify, DACA gave deferred action to those who came here as minors and graduate high school and college, okay? DAPA gave deferred action to the parents of U.S. citizens or lawfully permanent residents, okay? That was the problem. And again, under the various regulations that exist, when deferred action is granted, it triggers a provisioning of work authorization, which allows people to work legally and pay taxes and all the other good stuff. Okay. So what's the problem? A couple weeks after DAPA was announced, the state of Texas, on behalf of, I think, 20-something other states, filed a suit in federal court in Brownsville, challenging the legality of DAPA. Now, that case presents issues which we're not going to talk about. One aspect of that case is what's called the APA, the Administrative Procedures Act, and they said that this was a substantive rule, and the president did not go through notice and comment rulemaking first. I'm not touching that argument. I don't think Anil wants to either. Another big issue in that case is standing and justiciability, right? Did the state have text, have standing? I don't want to talk about it today, and I think it clouds it. If you like, you're welcome to touch on it, but I'm going to stay away from the standing and justiciability issues. The issue that interests me, and the interest I followed a brief from the Cato Institute, focuses on a clause of the Constitution that you probably never thought much about. And this clause is known as the Take Care Clause. And it says, the president shall take care that the laws are faithfully executed. Now, traditionally, that means the president must execute the laws. And he cites this as a way of saying, you know what, I got to do what I have to do. Congress, don't tell me not to. The argument here takes on a slightly different tone. It's, in fact, the argument is he's not faithfully executing the law. And I have two articles on this you want to read further. I will only briefly summarize. One was in the Georgetown Law Journal Online. One was in the Texas Review of Law and Politics. I encourage you to read both of those. But I'll try and give a sketch of why I think this action is unlawful. I'll start by saying is, again, this is a fairly novel claim, and I'm very candid about that. The court has not litigated this issue before. So I think these sorts of debates are actually helpful to flesh out the issue. So where do I start with my analysis? So on the same evening that the president announced DAPA, the Justice Department's Office of Legal Counsel, this is like basically the constitutional lawyers for the federal government, released a memorandum. And the memorandum, it's a 33-page memo. You can download it for free online. And it sketches out a legal argument of why they think that the Deferred Action Program is lawful. Okay? And I think the memo takes a fairly conservative approach. In fact, far more conservative approach than many law professors would have preferred. In fact, on the Balkan blog, which Anil wrote on others, Balkan and Dorf as well, sorry, many law professors were critical of the OLC memo for reasons I'll get to in a few moments. But the memo comes down to basically this, right? It recognizes that deferred action is not an express statutory grant, right? This has been recognized by the Supreme Court. Justice Scalia had an opinion on this as something that's kind of been acquiesced to. We have this thing of that basically Congress has, not really stopped the president from doing it. The president keeps doing it. In fact, Congress has enacted laws that reflect what deferred action is. But that's not a blank check. And I'm going to read you one sentence from the OLC opinion. Any expansion of deferred action to a new class of aliens must be carefully scrutinized to ensure that it reflects considerations within the agency's expertise, that it does not seek to effectively rewrite the laws to match the executive's policy preferences, but rather, here's the key, but rather operates in a manner consonant with congressional policy expressed in the statute. Operates in a manner consonant with congressional policy expressed in the statute, right? And that's the Obama Justice Department's rationalization. I don't know if it's perfect, but I think that's a pretty good place to start, right? If the executive is simply rewriting the policy, rewriting the law to match its policy, and it's inconsistent with congressional policy, I think that is something that would be unlawful. So what is the actual congressional policy here? I think there are two grounds, and two very specific grounds, on which the president's actions here fall short of congressional policy. The first is that the benefits, Neil's going to jump in and say the word benefits, but the deferred action of DAPA falls in a very specific class of aliens. This class of aliens are parents of U.S. citizens. And as we know under the 14th Amendment, if a person is born in this United States, they are a citizen at birth. They are naturalized at birth by virtue of the 14th Amendment, okay? But what about their parents, okay? The question is whether the parents should be benefited. The second reason why I think that DAPA is not consonant with congressional policy is that in the past, when it's been used as a bridge from one status to another, where the prospect of lawful status of some sort is waiting at the other end of the rainbow, so to speak. That's not the case here. So let me go through these two arguments in detail, okay? First, if you are a U.S. citizen by birth, you are born here, and your parents are not U.S. citizens, you are not able to petition for a visa for your parent until you turn 18 years old. This is not an accident. I'm sorry. Yeah, thank you. Until you're 20, even longer. So you're 21 years old, okay? This is not an accident. And if you go through the history of the INA, there is a very sensible discussion about why we do not want children who are born here to immediately petition for a visa on birth. I won't use the pejorative, but the one phrase is birth tourism. Okay, and there was actually a colloquy during the 1965 act between Senator Robert Kennedy and Senator Sam Irving. You know, these are no right-wing nutjobs, right? That basically said, we don't want people coming here, having children. Children become citizens by virtue of the 14th Amendment, and immediately petitioning for a visa for their parents. So Congress imposed a 21-year gap between birth and a visa petitioning to expressly disfavor this group. And I can go through various other instances where the law does not favor the parents of U.S. citizens. Okay, and indeed, Congress expressly rejected this when they voted down, or they didn't vote for the bill the president proposed. Okay, this element of the law is not consistent with congressional policy. The OLC memo kind of glides over this, but this specific element of the law is not consistent. The second, I think, far more damning aspect of the policy that's not consistent with congressional policy focuses on what the deferred action is trying to achieve. The Office of Legal Counsel identifies, I think, 4 other instances where deferred action was used on a fairly large scale. Okay, in each of these cases, the alien had some sort of existing lawful presence or the immediate prospect of a lawful presence that was forthcoming. So I'll give you the easiest example to remember, and maybe you can go through other examples in a moment. The easiest example goes like this. Say you are a foreign student in the United States studying at Tulane University in New Orleans. Okay, you had a student visa, you were registered for your classes, everything's awesome. Then in the summer of 2005, Hurricane Katrina strikes New Orleans. Tulane University shuts down. Okay, your student visa is immediately revoked because you're not carrying the requisite number of credits. Right? You had it. The hurricane struck, you lost your credits, therefore you were immediately subject to removal. Okay, President Bush instituted a deferred action policy for students who were in the Gulf Coast. He said like this: if you can enroll in another university by the next semester, by whatever the next semester was, we won't deport you. Right? So effectively, there was a brief period, maybe a couple, 5-6 months, whatever it happened to be, where a limited number of alien students were given this deferred action for the express purpose of bridging them from lawful status to another lawful status, right? On the other end of the rainbow, there was a pot of gold waiting for them. That simply does not exist for the parents of deferred action, the parents of US citizens. They need to wait up to 21 years, right, for the first to petition for a visa, right? The proximity of that 21 years is not consistent with how it's been done before. In each of the instances involving VAWA self-petitioners, the TNU visas, the Katrina victims, as well as the widows and widowers of US citizens, there was an almost immediate prospect of getting some sort of adjustment of status on the other end of the deferred action. That's simply not the case here. In fact, the president has said that, sarcastically, it will be very difficult for a future president to revoke those who have gotten deferred action to this policy. It's obviously not meant to be permanent on its face. In fact, there are 2-year licenses that are, of course, revocable. But if you look at DACA, there's almost a 99% renewal rate. People simply aren't getting this revoked. Whether the next president goes ahead and revokes it, I think, is a different question. But in my mind, this was used as a way to perhaps hopefully maintain the status quo, keep these people on a status, right, until perhaps a future Congress can enact legislation. That is not consistent with congressional policy. So for the 2 reasons, first, Congress has strongly disfavored this class from receiving these sorts of benefits. And second, this is not consistent with how previous administrations have used deferred action as a temporary bridge. I do not think this policy is consistent with congressional policy. And because we're in the domestic sphere, not the foreign policy sphere, whereas the president has very broad powers for foreign policy, we're domestic here, where Congress is king. And I do not think that this action is consistent with the Take Care Clause of the United States Constitution. Thank you very much.
All right, so my thanks to all of you for being here, and to Professor Blackman for coming all the way up from Texas to join us for this conversation. I would encourage you all to read his articles. Much of what I have to say draws from an article that I recently published in the UCLA Law Review, which is available online, Discourse, their online supplement. So Professor Blackman has given a political narrative about where the deferred action initiatives have emerged, right? From the failure of the DREAM Act and from the failure of the bipartisan immigration bill that the Senate passed, the failure of that to be adopted in law in 2013. And what I want to suggest here is that to really understand where these initiatives come from and their permissibility and what they're actually doing, we need to have a broader and longer legal narrative about immigration enforcement and the nature of government priorities and how they've evolved over a longer period of time, which I think might suggest some limitations to that political narrative, and also might clarify where we do or don't disagree on some of these issues. Okay, so because there have been some much longer term changes that are going on in the nature of immigration control, and the nature of immigration more generally in the United States that lead up to these initiatives. So let's just go back to 1965. 1965, there were roughly 10,000 people removed from the United States formally. 1986, we're talking about 24,000 or so. In circumstances when there are about 3 million people who are undocumented. By 1996, we have approximately 6 million people who are undocumented, and removals have increased to about 70,000, 69,000, I believe. Today, we have approximately, the best estimates are between 10 and 11 million undocumented individuals. That number has gone down a little bit. The number of people who are formally removed every year is now on the order of 350,000 to 400,000 people per year, right? More than at any other time in United States history, leading some immigration advocates to describe President Obama as the deporter-in-chief, right? And that's not meant to be a compliment. So at the same time, you also have a broad expansion in the grounds of removability in the United States, particularly in the mid-1990s, and massive growth in funding to seek removal of more people, right? So, but at the same time, even with that massive growth in funding, and especially given the expansion of the grounds of removability, congressional appropriations really only permit enforcement action against a small fraction of the individuals who are potentially removable. The number that you hear frequently is what the scale is now, about 350 to 400,000. But bear in mind, there's no fixed mathematical formula to say that translates this level of money equals this many deportations. It could be more or less expensive in any given case based on a variety of different factors. Some categories of cases are more complex and more resource intensive. The agency's given us that estimate of it based on its existing practices, but I think that's also an important nuance to understand here. So in this context, it's an inevitability that the agency and its officials will exercise prosecutorial discretion or enforcement discretion, I'll use those terms interchangeably. The agency has to make choices, and its officials have to make choices because they can only go after a fraction of the individuals who are suspected of violating the law. Now, there are lots of different forms in which that discretion takes and mechanisms that can be used. And the discretion gets exercised at every stage of the process, from before seeking to even target particular individuals to, or categories of individuals, to the moment that somebody might be taken into custody, and at every stage subsequent to that, all the way to the point of judicial review. We could put whether there's a stay of removal. That's another form of discretion, and at every stage in between. In some instances, there may be equitable or humanitarian reasons not to pursue enforcement action against particular individuals. But enforcement discretion, its exercise, is inevitable. Now, deferred action is one form in which that exercise of discretion takes place. And for people, as Professor Blackman mentioned, for people who are eligible for DACA or DAPA, that's the form that it takes. That's what the guidance authorizes. Deferred action has existed for decades. Thousands of people have received deferred action, notification of deferred action over the years. What is it? So here's what it's not. I'm glad Professor Blackman pointed this out. It's not executive amnesty. It's not Obama handing out green cards to people. Although that is sometimes the kind of claim that is made in political discourse. It's the kind of claim that I think emerges in other ways in the litigation challenging the initiatives. This should be a fairly obvious point, but I think I want to dwell on it just because there's so much misunderstanding about this, right? So why is deferred action not the same thing as legalization, right? So people who are lawful permanent residents have a durable entitlement to remain in the United States indefinitely. They automatically have authorization to work. They can travel to and from the United States more or less freely. They can sponsor certain qualifying relatives as immigrants. They may be eligible for certain government benefits in certain contexts. And after a relatively short period of time of 3 to 5 years, they might be able to naturalize and become US citizens. The government could deport people, but it requires clear and convincing evidence in an adversarial hearing with the right to judicial review. People who are non-immigrants, but lawfully in the United States, might also have durable entitlements to remain in the United States for temporary periods of time with similar kinds of procedural protections. So contrast deferred action. All that deferred action is temporary revocable notification that the agency has put the individual on a list of people who are not presently enforcement priorities. The original term for deferred action going back from 1960s to 1970s is in fact a little bit more descriptive. It's referred to as non-priority status. And the government maintains this list of people who are non-enforcement priorities. Nobody has the right to deferred action. If it's denied, you can't appeal it, that denial. It's not immunity from deportation in any sense because it can be revoked at any time. If it is revoked, you don't have an opportunity in any formal sense to contest that revocation. Doesn't confer any right to travel outside the United States, no eligibility for social service benefits. It is inherently tenuous and only results in what might be understood as immigration purgatory, as Professor Shobha Sivaprasad-Wadia has described it. And the eligibility for under the guidance for DACA and DAPA make clear that it is to be granted on a case-by-case basis. And here I should also point out what will again be fairly self-evident to anyone who's spent even a little bit of time studying immigration law. Immigration is not a binary phenomenon where you have people who are legal and people who are undocumented. There is a dizzying array of different combinations of rights, privileges, and responsibilities that non-citizens might be recognized as having. And that, by the way, goes for undocumented immigrants too, right? Because undocumented immigrants are not entirely beyond legal protection or recognition by virtue of being in the United States without authorization. They are subject to, there are plenty of rights and legal entitlements that undocumented residents have. Think, for example, the ability to make contracts. The contract is not void simply because the person entering into it is an undocumented immigrant. And we could go with a long list of other things. The particular combination of those rights, privileges, and responsibilities often is not the function of any single status determination. It's disaggregated. There are lots of different sources of legal authority that govern what that picture looks like. And so true for people who get deferred action. People who are given notification of deferred action might have and can have access to other kinds of rights, benefits, entitlements, and responsibilities. So for example, to take the one that seems to attract the most attention, work authorization. Work authorization is not granted automatically by virtue of somebody receiving notification of deferred action. Since the 1960s, immigration officials have exercised authority to grant or deny employment authorization to different categories of non-citizens. People who have received notification of deferred action are one of them. There have been formal regulations governing that since 1981, which were adopted under notice and comment rulemaking. And then when Congress adopted the Immigration Reform and Control Act in 1986, which put into effect an employer sanctions regime, it legislated against the background of these practices and regulations and expressly confirmed this regulatory authority by granting, by recognizing that non-citizens may be eligible to work in the United States if they are, 1, lawfully admitted for permanent residence, 2, authorized to be employed under the statute, or 3, authorized by the Attorney General. Now the Secretary of Homeland Security shares that responsibility. So another example, driver's licenses. The Real ID Act allows states to issue Real ID recognized driver's licenses to individuals who have received notice of deferred action. And there are other kinds of things that might accrue under federal, state, and local law, but this is, again, a very highly disaggregated legal regime. It's not the fact of being granted deferred action or the guidance establishing DACA or DAPA that gives rise to any of that. Now, to ensure that, as I said, the ability and to enforce the immigration laws and take enforcement action is much more limited than the number of people who are potentially removable. So in order to ensure that that discretion is exercised in a rational manner, Congress and the executive branch both have established enforcement priorities and have really struggled, quite frankly, to implement those priorities in a meaningful and effective way. Right? So the agency is expressly authorized by statute to, under broad delegations of authority, to enforce the immigration laws and establish national enforcement policies and priorities. But really, it's also authorized by virtue of what Adam Cox and Christina Rodriguez would call de facto delegations of congressional authority. The legislative scheme doesn't permit deportation of everybody, and the appropriations only permit a small fraction of individuals to be deported who potentially might be. And in this context, bear in mind also, there's no statute of limitations. So the number only accumulates potentially if there's growth in the number of potentially deportable people. And in addition, I think this is also neglected in public debates to a certain extent. Congress itself has mandated certain priorities. So for example, the various provisions in appropriations legislation that Congress has adopted expressly instruct immigration authorities to prioritize enforcement actions against non-citizens with criminal convictions, to give violent crimes the highest priority, and then in part to base the rest of their priorities on the severity of those offenses. So in this context, policymaking officials have long issued guidance documents communicating what those agency priorities are and providing direction on how enforcement discretion should be exercised. And this is true at every stage of the removal process, as I mentioned. And to carry out those priorities and to ensure that this guidance is meant also to ensure that when the bureaucracy implements the law and enforces the immigration laws, they're doing so in a manner that heeds other rule of law values, such as consistency, transparency, accountability, and non-arbitrariness. So we can go back into the 1990s and see the emergence of this process. 1999, a bipartisan group of 28 House members from the House Judiciary Committee criticized the INS for not paying more attention to humanitarian considerations when exercising prosecutorial discretion to enforce the relatively harsh provisions of the '96 immigration laws, and requested specifically that the Clinton administration should exercise stronger guidance to encourage more consistent use of prosecutorial discretion within the immigration agency, which is of course true in the criminal context. The US attorneys in the United States are governed by a very detailed US attorney's manual, and they explicitly invoked that as a model. So since then, the INS commissioner has in fact put forth a detailed policy statement setting, here are the agency's priorities, here are the factors that should guide the exercise of enforcement discretion through the agency. Factors that might include the immigration status of the individual, the length of their residence in the United States, criminal history, humanitarian equities, a whole bunch of other things. These principles have been consistently reiterated. The Bush administration reiterated these principles on more than one occasion. But despite these efforts, and especially as the number of people subject to removal has increased, the enforcement patterns in the field have been, one, inconsistent, so like cases are not being treated alike, and have diverged significantly from these priorities and guidelines established by policy-making officials. And we can talk about the factors that have contributed to that divergence, but this growth in the scale is one that you cannot ignore. So this complicates the agency's supervisory task of ensuring that when the enforcement bureaucracy in fact implements immigration law, it does so in a manner that is consistent with the rule of law. So the Obama administration, very soon after coming into office, has tried to address this divergence by communicating the agency's guidelines and priorities more concretely. But those initial efforts were largely regarded as unsuccessful. So DACA and DAPA have to be understood in that context as a logical next step. And what they do is, rather than exclusively delegating discretion to the frontline officers to grant deferred action and then giving them effectively plenary authority to apply the detailed but often open-ended criteria of earlier guidance documents, the initiatives have a parallel framework that divides the exercise of discretion into 2 layers. So the first layer involves, at a more senior level, exercise of discretion to establish what is the decision-making framework, what are the factors, who should be, in fact, considered for deferred action. And then the second layer, and those criteria, in fact, actually, the eligibility criteria are very close to the kinds of factors that have long been in the agency's priorities. And then the second layer says to rank and file officers, apply those criteria and decide on a case-by-case basis, individualized basis, whether to grant deferred action. And in addition, rather than leaving that to be done primarily by frontline enforcement actions and officers in ICE, the process now involves USCIS, because ICE officers have an incentive, as other law enforcement officers do, to make certain numbers. And there's been some indications that that sometimes rises to the level of a quota. Whether even short of a quota, that kind of numbers-driven approach, which law enforcement itself often resists, can sometimes distort the ability to apply those factors. So I'll stop there. I'm sure there are a lot of other issues that will come up, and I'll hold off on commenting on some of the points that Professor Blackman is saying.
So before I open it up to questions, I guess I'll just give you guys an opportunity to do that, because Professor Blackman, if I had to summarize Professor Kalhan, he says an essential part of the executive branch's discretion, and that these policies make that discretion more transparent, more consistent. So is your position against the historically exercised executive discretion that we see throughout all aspects of executive action?
So I don't disagree with anything he said. In fact, I think almost every syllable of what you said was accurate. I actually agree with just about everything you said.
Well, I'll leave.
Yeah, no, but also he didn't reply to anything I said, so it was, I think that's part of the reason why. So look, staffing is difficult. Executive branch officials are not very good at doing their jobs, and I understand that various Border Patrol agents were not very good at doing their job. They should be fired, right? You don't need a massive regime. Lay them all off, but various union laws probably protect them. But if you have people who are breaking the law, they should be terminated, right? I don't accept, and I actually wrote a response to Professor Motomura in the Washington Law Journal, that this background problem warrants DAPA. That part, that was a syllable I didn't accept. But to David's point, do I think that executive branch agents don't have discretion? Of course they have discretion. They can prioritize however they want. But that prioritization must be consistent with congressional policy, which is what the OLC memo said. And for the reasons I laid out, I don't think this is consistent. The scope and breadth of what they've done is simply not consistent with anything that's done before. When you do not have an express statutory authorization, I think Adam Cox, Christine, have it right, there's de facto delegation. But there are limits on what the de facto delegation is. You have to look to what has been acquiesced before, and simply has not been done. I'm actually going to debate with Adam Cox on this exact topic tomorrow at NYU, so I'll be sure to bring that up again. But no, David, there's absolutely discretion. In fact, if they simply said we're going to prioritize, felons over families, there would be no lawsuit. But it was the institution of this massive program to announce it, to provide deferred action, which then triggers the benefits, as Neil said, were provided for, was effectively trying to create a class of people who could hold on until perhaps some future legislation is being passed. This is not consistent with how deferred action has been used before, and I think it's a bridge too far.
So let me just clarify. So my position is not that immigration enforcement officers across the board are bad at their job and should be fired. I mean, that's not really the point. The point that I'm making with that part of what I'm saying is that when you have discretion being exercised on a very large scale, it needs to be guided in order to ensure that it's consistent, that there's transparency in what's guiding it, and that it's accountable, right? So that is in fact, those are rule of law values that the senior policy-making officials and the president, for that matter, are vested with the authority to ensure in the bureaucracy. Okay, so now, when I hear you say that you have no problem with enforcement priorities, then but if guidance cannot be issued to ensure that those priorities are carried out, then those priorities aren't that meaningful. priorities and discretion have to go hand in hand. In terms of consonance with congressional policy, here's precisely why I was taking some care to emphasize what deferred action and what is and what it is not, right? So deprioritizing somebody for removal does not, in fact, conflict with anything that Congress has provided for in terms of who then can get lawful status. So the fact that the people who might be deprioritized under the guidance for DACA or DAPA are not people who then can be sponsored for permanent residence, I mean, that doesn't bear relationship to each other.
So I guess then, Professor Kalhan, to sort of capture, I think, Professor Blackman's main point and push you a little further on that, is there any way that you see that this is, the executive is going contrary to what Congress wants in the ways that Professor Blackman identified, creating a big regulatory scheme that DAPA and DACA do, as Professor Blackman claims? And are you concerned that it would give the executive too much power, maybe not now issuing just this deferred action, but going further into some of the things that you say this doesn't do in the future? Are you concerned that this is too much for the executive?
In this instance, no, and there are a few reasons for that. One, the delegation to the executive branch in this case is quite broad. I mean, that may be bad from a policy perspective, right? Maybe we'd be better off if Congress, in fact, actually delegated in a more constrained way, right? And I don't even feel like I need to speak to that right now. It's certainly the case that if the executive branch deprioritized, for example, people with violent crimes, or decided that we're going to, in fact, actually not focus on people with criminal convictions, and we're going to, when Congress has expressly said, please do that, not please, you must do that, that would be a problem, right? If the executive branch didn't spend the money that was appropriated to it for enforcement activities, then that would be a problem. Now, one might say that, well, okay, could you spend all of the money going after one person? I mean, I think that's somewhat, that the absurdity of that example sort of might suggest that it's not very likely to happen. But to the extent that there's any concern about that, I don't know that there are judicially manageable standards to navigate that. I mean, look at the structure of the debate we have right now. Not the two of us, the debate in public discourse. One side says, the president is abdicating law enforcement and just not carrying out the will of Congress. The other side says, this is the deporter-in-chief. He has deported more people than anybody in human history. How do you navigate between those two? I mean, that seems to me strikingly akin to a political question, right? Which, we could have different policy views about that and come out on one side or the other. I don't see that as a problem with in constitutional terms.
I just got a brief response. I agree that the INA is quite broad, and there's very few syllables we depart on, right? It is quite broad, but there are some teeth there. And the two items identified, that Congress has disfavored the parents of U.S. citizens, and Congress has only acquiesced to deferred action serving as a bridge. Those facts are there. We have this record. That's there. And to the extent that we look at consonants, I think those are two arguments that cut against how broad this authority is.
Although when you say disfavored, I mean, we should be clear, right? There are lots of categories of people who are much more strongly disfavored in immigration law, and that's precisely who the administration is prioritized. Not just this administration, most administrations.
Right, but among family members with familiar relations, actually number one, the most disfavored status is the parents of the U.S. citizens for the exact reason of birth tourism. That's been a serious concern of the Americans. Even today, it's in the popular discourse with dare I say, "Make America Great Again," right? It's a big issue today, and I think that the policy favoring this group. Now, one thing we haven't mentioned is what OLC said you cannot do, right? What about the parents of the Dreamers? Okay, these are the people, the people who got deferred action under DACA. Can their parents get deferred action? And OLC said no, because there's absolutely, I'm summarizing a little bit, but there's really no familial relationship that Congress has warranted between a person on deferred action that their parents then receive. So there are teeth there. There are limits of how closely we hew to congressional policy. Many law professors disagree with that move. I don't know your position.
Yeah, I do disagree with that. I mean, in this following sense, I mean, I don't think that necessarily, I mean, I think that the effort to tease out a very consistent, very coherent picture of what congressional priorities are here is not quite right. I mean, it's a little misleading in the sense that I don't think that the fact that these are individuals who might not have a path to citizenship, to permanent residence or citizenship, or even non-immigrant status, does not have any, automatic relationship to whether that makes it impermissible to deprioritize their removal. Deferred action, by the way, has been granted for decades to people with no path to anything, just simply on humanitarian grounds.
Well, but that was with foreign policy, though. Those are people abroad in the president.
No.
Yes.
No.
Well, give me an example.
I mean, they're individual people who have been granted deferred action purely on humanitarian
From
basis.
which nationality? Specific countries with humanitarian
I mean,
crises?
the immigration lawyers in the room could probably...
No, and I know this, and the IA released this report saying, here's deferred action like to Eisenhower, right? In virtually every situation, like the boat people, these are specific groups with foreign policy arguments. I think the president has specific aspects as a commander-in-chief for the entire world to grant humanitarian relief. DAPA and DACA, regardless of citizenship, what country you're from, Canadians and Mexicans will be treated exactly like. I think that argument doesn't work. The 4 programs that OLC did look at, the VAWA self-petitioners, the TNU visas, the Katrina students, and the spouses of the widows of spouses. No, the spouses of widows, right? The widowers, right? Those are specific domestic groups, irrespective of nationality. And those were groups where there was a bridge. This was not purely humanitarian. In fact, OLC disclaimed that DACA was based purely on humanitarian concerns. They were looking to this consonance with congressional policy.
But the use of deferred action long predates any of those examples you're describing. I mean, deferred action, and for that matter, other forms of prosecutorial discretion have long been used. Now, they've not been used subject to the kind of guidance that this might involve. That might be true. But the circumstances are also very different. I mean, again, remember, in those periods of time, the number of people who were potentially deportable and also who were actually being removed was much smaller.
Okay, we'll go to Q&A? Yeah.
I'm going to jump in and open it up to everyone out here. If you have questions for either or both, and hear from you guys.
And please say your name when you ask the question, where you're from. Thanks. Come on. We weren't interesting enough, I guess.
I guess I'll start.
Go for it.
Jonathan Polito, first 1L from New York.
Thank you.
I understand your position is more just like on the letters of what congressional policy has been. Yours has been more of just like the overbroad historical benefits and detriments to people and to who people are affecting. I guess my question is, on your terms, how is this just to tell people who are parents that they cannot take care of their children throughout their lives? Because you have to give them 21 years to raise them. How is this just to the states themselves who have to take the burden on taking care of these children forward? I see the president's actions as more unorthodox to what Congress has stated. And we do have these situations where, like Katrina, where we do have people who are either by their status, they can't continue, they can't fulfill what the law says. But if the job of Congress and the job of the president is to adapt to these situations, why isn't this just that same thing, where we have a situation where we have these parents who cannot, by congressional law, be here to take care of the children or of any other status, to adjust it? And that's like what the president's doing, adjusting the situation
So,
to further.
okay, so thank you. So the first question is, thank you for the very, very thoughtful question. The president does not have the power to adapt. He has a duty to take care of the laws of faithfully executed. Until Congress changes the law, he can't just make it up on the fly. So to your second point, absolutely, the requirement of Congress to have a 21 years petition has the serious threat of ripping families apart. It does, and that's what Congress did. And the president's action bypasses that. That's an argument in my favor, right? Congress deliberately made it very tough for families where the child is a citizen, the parents are not. They said, you have to wait 21 years, and if you get removed in the meantime, too bad. That's from Congress.
Okay, but just to sort of respond to that, I mean, so if under the enforcement priorities, the categories of individual who are eligible for DACA or DAPA are people who are not likely to be high priorities, right? They're not going to be removed in the foreseeable future unless in the exercise of discretion, there's some federal interest that leads that to happen, right? So, from the perspective of the Take Care Clause, I mean, the continued presence of people, large numbers of people who are not likely to be deported anytime in the foreseeable future, and particularly this category of people, can create a lot of problems. That the president is not, the take care clause is not just a take care to make sure that everybody who might be deportable is deported clause, right? Take care to be faithfully executed. First of all, it must account for these other, or certainly allows for the president to account for these other rule of law values. Certainly, if one were to take the position of a strong unitary executive, that would be the case. But secondly, there are other laws at stake here, right? So criminal laws. If people who are in the country unlawfully and are not likely, and we know they're unlikely to be removed in the foreseeable future, they're less likely to cooperate with law enforcement as witnesses or victims. Workplace laws, right? Studies clearly show that if workplaces that are populated by people who are undocumented and not authorized to work have high levels of health and safety problems, wage and hour law violations, other workplace law violations, right? And individuals who are undocumented are often dissuaded from reporting those violations or cooperating with Labor Department investigations, right? Welfare laws, right? You mentioned that if the children are United States citizens or lawful permanent residents and their parents are not, in fact, if they're undocumented, they may work unlawfully, but they may not work at all, and those children and lawful permanent resident children might, in fact, actually be have to access welfare benefits. Of course, the purposes of the welfare laws is not to just give money to everybody who might be eligible, and like especially since the mid-1990s, it's to minimize the number of people who in fact actually have to take advantage of those and receive the benefits of those laws, right? So remember, people that are undocumented don't mostly live in isolated enclaves. They are part of mixed status families, mixed status communities, and the circumstances in which they live have profound effects on the lives of U.S. citizen and lawful permanent residents to whom there are legal obligations. So, take care. The president has to, and Kate Andreas has a great article which sort of points out the fact that the enforcement and non-enforcement power often, requires consideration of cross-agency concerns and cross-statutory concerns, right? So that's what I think in some sense there's a way in which that's relevant to what you're saying.
Okay, another question. Yeah.
Yes, sir.
For Professor Blackman, I'm not sure exactly your relationship to the Cato Institute. I guess
I'm an adjunct scholar. It's an unpaid position where they let me file briefs. I don't pay the filing fees.
I was a little bit curious as to whether. Oh yes, David Benyon, Philadelphia immigration attorney, and I was a little bit curious as to whether opposition to DAPA, for the reasons that you've outlined, is an official position of Cato. Was there, to your knowledge, any internal discussion about this issue? And I raise the point because of some individuals who work for Cato, for instance, Alex has come out quite strongly in favor of what you could call open borders, or you could also call a strong presumption in favor of liberal immigration. So I was curious about that because I guess the Institute's position on this particular issue seems like it could be in conflict with its general position on immigration.
So I'm glad you asked that question. I'm actually, again, I'm an adjunct scholar. Cato is an unpaid position, which basically means I can file briefs and they can place my op-eds. It doesn't get me much more than that. The shorter answer is Cato has taken both positions. They favor the president's immigration policies, but they think the president acted unlawfully, which is exactly what I said at the outset of my speech. I support the president's policy as a matter of policy, but I think this is unconstitutional. And I think those are entirely consistent with Cato's values of the rule of law. I mean, we have a very different conception of the rule of law, perhaps, but the president's acting unlawfully, the policy is secondary. And Alex's work I respect deeply. I think he's written some great stuff. But the Cato Institute's position here, I think, is entirely consistent. And again, I'm not actually speaking on behalf of Cato, but in my limited capacity as an adjunct scholar, which I was appointed a couple months ago. I wasn't even an adjunct scholar when I wrote this brief. Thank you for your question. Appreciate it.
So maybe one more question, and then we'll wrap up. Yeah.
You seem to focus a lot of what you're saying on past uses of deferred action. It's different, but at least from my observation as an immigration attorney, at least for people here that are post final order or they have order removal, they've been for years based on a form of deferred action, the order of supervision or a stay. And it's actually, we've met with our local field office director who said they've always had their policy in the past several years of not deporting people who come off with serious criminal issues. So at least when we heard about DACA coming out, it seemed to be no different from what's already going on, except for the categories of people who have less immigration violations and haven't already been caught and were removed. So how do you reconcile that?
So I think
I'm sorry, can we just take the second question as well and then answer them together?
Oh, yeah.
Yeah, I think the short answer is
Wait,
Josh,
just
hold on.
one
Let's take the second question. You can answer.
no. I'd rather do one at a time.
You want to do one?
Yeah. So I think the short answer to your question is this: ad hoc deferred action is very long-standing, and it is indeed case by case. But DAPA is different. It's a class-based affirmative action. A class-based deferred action applies to a lot of people in the same sense that the VAWA petitioners, the TNU, the Katrina people, it applied to a class. I think you have to distinguish this from the individual ad hoc use of deferred action.
But this, I just want to clarify. I mean, to describe this as class-based is a little bit misleading because what it's doing is setting forth eligibility criteria, but there is still case-by-case discretion being exercised as to who gets it, and if there are ways in which it can be deviated in either direction.
So there's like a 97% grant rate, and the DOJ has been basically unable to write a single instance where someone was denied for purely discretionary reasons. That people had, maybe they were perjury or something before, or crimes. There's no one actually denied for discretionary reasons under DACA. So I would quibble a little bit.
But I don't know if that's entirely true. I mean, first of all, when you say 97%, I mean, a lot of people have been denied. I mean, I think it would come as some surprise to the however many thousands of people who've been denied that there's, this is just a rubber stamp or something like that. I mean, and secondly, to focus on the statistics is also somewhat problematic. I mean, think about what this involves. People who apply are registering with the government. They are giving detailed personal information, biometrics, fingerprints. This is a self-selected group. I mean, there's no reason to assume that the people who are coming forward to seek deferred action under DACA or DAPA are a representative sample of everybody who is potentially removable. I mean, that's sort of, I mean, think about other things that have really high rates like that. Wiretap applications, search warrant applications. I mean, it doesn't automatically follow that the process that's being involved is a rubber stamp and there's no meaningful process taking place.
And I agree with that. I think that's the reason why you're not going to find felons.
But it's not meant to find felons.
If this is meant to separate felons with families, it won't do a particularly good job because felons will not be registering because they'll be afraid of being identified and removed.
But I think that misunderstands what the point is. I mean, the point here is to deprioritize people so that at the earliest possible stage so that resources are not expended. I mean, once somebody is in fact arrested, taken into custody, placed in detention, and you are in fact pursuing their removal, at those stages, that's when you really start to have some serious resources being spent. So this in fact is reducing the pool, and it's USCIS doing it. So this actually is meant to be freeing up the enforcement resources of ICE to focus on the priorities of the agency. It's not meant to sort of trick and lull people into seeking to apply and then saying, gotcha. That's not really the point. I mean, maybe some people will be identified in that process who should appropriately, the government will seek to engage in enforcement action against them. But that's just because it's not doing that doesn't mean that it's not in fact actually operating to implement the priorities of the agency.
And we'll go to the second part of the question. I didn't mean to cut you off, but I wanted to hit that part first.
Okay, so yeah, let's take just your question and we'll be done. No?
I
Okay.
have one question.
Yeah.
I have a statement on this. Isn't this something
Put a question mark into the statement, okay? just inflect your voice up like I'm Ron Burgundy.
My name is Kalhan, also one of the questions I have is, couldn't this all been avoided if President Obama simply published this in the Federal Register?
Well, that would have dealt with the APA claims, right? But the problem is they've actually had to have an analysis open to the public, which they did not want. They want to just announce this and do it. What's interesting to me, and maybe Anil and I might agree on this point, is why they haven't done that yet, right? Why haven't they just went ahead and published in the Federal Register and moved the entire damn case? I don't know, Anil, do you want to talk about that?
Well, I mean, I don't have a great answer to that. I mean, I think that there are certainly some people in the immigration advocacy community, the immigration lawyer community, who would prefer to see that, right? If you in fact actually have a process like that, that's implemented through notice and comment rulemaking, that may allow some of the rule of law values that I'm concerned with to be implemented to a greater extent. I mean, I think there are probably costs and trade-offs on the other side. It would look very different. I mean, I think that would look like a very different kind of regime than the one that's implemented by guidance with a lot of discretion at the end of it. It would not obviate, of course, the kinds of arguments from the constitutional perspective.
I still
critics
complain,
have-
but we'd at least have the process.
Right, and there would be litigation. The litigation would have probably proceeded in a similar way.
But the one, and maybe we'll agree a point, I don't think the president wants to kick this to notice and comment because they push it past 2016. I think the one risk is, and I've done the math on this, we can maybe end in a point of agreement. If this case goes beyond 2016 and there's a Republican president, a policy that never went into effect will never go into effect. DACA will probably stick around, but a president, Marco Rubio, will not implement DAPA. President Clinton, I'm sure, will jump on this and expand it. But there's a serious threat that by not going through the proper process, they've just burned the last 3 years of the Obama presidency, and just they will not be able to get this thing done. And Texas followed their suit when they did. But numbers-wise, it's going to be very hard. Even if the Supreme Court rules in this issue, which they very well may, in June of 2016, which is what we're actually looking at this point, the president will have 4 months to do it. It's not going to get done. And I think that that's probably what's going to end up happening.
Well, thank you so much, Professor Blackman.
Thank you, sir.
Professor Kalhan.